We have formed a quorum, and it is also time to start the meeting. So I call to order the meeting of the Subcommittee on Merchant Shipping, Control of Harmful Anti-Fouling Systems on Ships Regulation and Merchant Shipping Prevention and Control of Pollution Fees Amendment Regulation 2015. Election of chairman. The details have been set out in members' brief. We need oral nomination by one of the members to be seconded by another member and to be accepted by the member nominated. Mr. Frank Yik, any seconder? You are familiar with the ships? No, you can't. I will do it. Thank you. Mr. Yik, would you accept the nomination? Yes. Any other nominations? No. Because we have only just got enough members to go through the procedures. Okay, I declare that Mr. Frankie Yik has been elected as the chairman of the Subcommittee on Merchant Shipping, Control Harmful Anti-Fouling Systems on Ships Regulation and Merchant Shipping Prevention and Control Pollution Fees Amendment Regulation 2015. So let's swap the seats. Members, would you like to elect a deputy chairman? If there is no need, then let's invite the administration to join us.
I
would like to welcome the team from the administration. We would like to welcome Ms. Jenny Chen, Principal Assistant Secretary Transport. From the Transport and Housing Bureau, Mr. Lai Ying-Keung, Chief Marine Policy from Marine Department, Ms. Joyce Chen, Assistant Secretary Transport from the Bureau, Ms. Carmen Chi, Senior Government Counsel, Mr. Jonathan Luke, Senior Government Counsel acting from Department of Justice, as well as Mr. Feng Ching-Yi, Senior Surveyor of Ships, Maritime Policy from the Marine Department. Welcome, ladies and gentlemen. I'd like to give the floor to the administration, and please brief us on the two pieces of subsidiary legislation. We'd like to make a new regulation under CAP 413, Merchant Shipping Prevention and Control Pollution Ordinance, namely the Merchant Shipping Control of Harmful Anti-Fouling Systems on Ships Regulation, for the implementation of the International Convention on the Control of Harmful Anti-Fouling Systems on Ships 2001 in Hong Kong. In other words, organotin cannot be contained in the anti-fouling systems on ships once the regulation comes into effect. And in fact, a ship of 400 gross tonnage or above that is engaged in an international voyage must also have a valid international anti-fouling system certificate issued by the flag state or its recognized organizations. Hong Kong ships may apply to the Marine Department to be issued with an IAFS certificate. On the principle of cost recovery, the owner will be charged the cost. So we'd also like to amend the Marine Shipping Prevention and Control Pollution Fees Amendment Regulation 2015 so as to recover the costs involved. The Director of Marine has already consulted the shipping industry, and we have got the support of the shipping industry. Your views are welcome. Thank you. Dr. Kenneth Chen has raised his hand, and so has Mr. Poon. I think we've got sufficient time, 5 minutes each. Thank you. Thank you, Mr. Chairman. Well, I have a few questions here. Of course, the first one is about the letter from our legal advisor to the administration. I hope that you will give the opportunity to the legal advisors to exchange their views on the basis of the exchange of the correspondence. I think this in relation to the definition as well as the interpretation part. So just to remind the chair of the need to do so. And then I come back to my question. Merchant shipping control of harmful anti-fouling systems on ships regulation is my focus. And then I would like to go to 3.2, which is the scope. I think some of the ships do not have to be bound by this piece of legislation. First of all, military vessels and also ancillary vessels, or a vessel used by a government for non-commercial activities. Well, this is the so-called exempted types of vessels. I would like to know about the origin. Does it come from the convention itself? If it is, please refer to the relevant parts of the convention. Nonetheless, it depends on the government's reply. Nevertheless, I would like to ask the Marine Department the following question. That is how to understand the three exempted categories. Do you have any way to tell whether it is a warship, a naval auxiliary, or any other ship owned or operated by government and used only on government non-commercial service? Or is there a register for such ships so that we know that the convention won't apply to it, and also the local regulation concerning the inspection and issuance of certificates will not apply to such vessels? Yes, administration. I would like to thank Dr. Chen for his questions. Well, for Regulation 3.2, that is the one read out by the honorable member, that's in relation to the regulation not applicable to certain types of vessels. We are following a specific provision in the convention. Did you just copy it from the convention? Yes, it's a matter of direct reference approach. Article 3 of the convention, yes, copied from the convention. And also for CAP 413, we have also got similar provisions for the application of other provisions of the convention. As to how we can identify such vessels, I would like to defer to the Marine Department. Thank you. Well, it is very clear. The ships that I'm referring to are ships involved in the acts of state, like warships, naval auxiliaries, and they also cover ships owned by the government, like the police launches as well as the fire boats. Generally speaking, this type of vessels will not be regulated under the convention, but still, for the government fleet, we will also ask the anti-fouling systems to be free from harmful substances. Mr. Chairman, well, for the government fleet itself, yes, under this regulation in accordance with the international convention, such ships should be and could be exempted, but we have been assured by the department that the harmful substances will not be used. So is it 100% sure? Okay. What about warship and naval auxiliary? I think we have got another piece of legislation. We did scrutinize that piece of legislation. We want to know under what circumstances can we confirm that a ship is a warship or a naval auxiliary, because the layman may not understand the term in the same way as the government. So I would like to know how the government can identify whether a ship or a vessel is a naval auxiliary, or is it simply up to the commander of the forces to say whether it is or not. I think we've explored this issue in the past. Yes, let me try to explain. Generally speaking, we can classify the vessels according to ownership or function. Now, we can say whether it is for business or not. In the case of a government vessel, it may be a warship or for other purposes. Say, for example, it can be a vessel for the purpose of training, rescue, or exploration. So they are they are not for business. They're not for, but then they still provide a certain kind of service, and they are on non-commercial service. And then the owner will be a government. Then we will say that it is part of the government fleet. I hope I have explained myself. Dr. Chen, I'm sure you can supplement because it was discussed last time. You gave us the official reply, but we know that in reality it may not be the same. We may have warships visiting our port, and then we have commercially run barges, etc., to take the military, the naval officers to come ashore for shopping and other things. So will they be regarded as naval auxiliaries?
When we scrutinized another regulation related to vessels and ships, the government was not so adamant that it's warship, naval auxiliary. It seems that at that time the definition was wider. May I hear from the government? Just now you have answered that it's very clear that they are registered with the government, or they are registered to be government vessels, or those belonging to the forces. And now, what if some vessels are commissioned from the private sector for use? We know that you would have to make it clear beforehand. But when it comes to Hong Kong's waters, they are operating. Say, as my understanding, if it is longer than 24 meters, under 500 gross tons, and if it is not ocean going, is excluded from the application of this regulation. That's right. Let me finish, perhaps. Then we have a problem, because if it's included, then it's fine. If it's excluded, then they may use non-compliant paint. Would they be regulated as well? Another question, and I've asked this question before the meeting. It seems that in the market there is no non-compliant paint for sale, that is those for anti-fouling system. Is that really the case? If it is indeed, then there is no problem. Section 3 of this regulation is about application. It applies to a Hong Kong ship wherever it may be, or a non-Hong Kong ship within the waters of Hong Kong. In other words, all ships are regulated. But when it comes to the statement, you know that for some vessels they have to go through a survey to obtain a certificate. Under 400 gross tons and longer than 24 meters, and if they are not ocean going, then they are excluded. But sometimes it depends on the size of the ship and where they are and the use. So whether they are actually applied depends on the actual ship. When it comes to whether paints contained inorganic inorganotin compound, we have a while back appeal to the market to not use paints that use this organotin compounds, and there is also a regulation in 2004 that prohibits the use of volatile organic compound. And since then, we have not issued any import license. In other words, there is a prohibition of import of organotin compounds for about 10 years. Well, if there is no paint containing this substance in the market, then it doesn't really matter what paint you use. Well, I think you're just making something out of nothing if that is the case, because you need to have something before you regulate it. Well, it's not something that we have never seen before. When the international relationship was tense, sometimes some civil vessels have been commissioned to launch for a specific purpose. So there is actually a gray area when it comes to like naval auxiliary or things like that. You can't tell us that it won't happen. If you say that, if the commander said it is such type of ship, then it is. Then we'll know that they're excluded. Otherwise, there will be enforcement action. When we were discussing another regulation, the government gave us an answer. Well, since there are exemptions enshrined in the international convention, well, I suppose the government will have their own understanding that are supported and justified. The public have to be made clear as to what the scope of exemption is. If you can give me a reply, well, perhaps you can give reference to what you said. When we're scrutinizing the other regulation, compare the two to see if you need to revise your answer. Perhaps it can be done by way of information paper. Last time you gave an answer, it was accepted. Next, Mr. Poon Siu Ping. We amend regulations to follow the international convention. That itself is a good thing. We hope that it can be done as soon as possible. I'm not very familiar with these regulations, and I'd like to get more information. You said that in the 90s, the government appealed to the trade to not use these harmful paints. Well, has the Marine Department made an assessment as to the number of vessels that are still using the harmful anti-fouling system? There is also the consideration of fees. The fees will be based on a cost recovery basis. Government surveyors charge about $3,200 for an hour. So that's already the cost recovery level. In the future, based on what will this level change? Who is to answer? And as to whether there are vessels using the paint that is prohibited under the regulation, I can tell you there is none. That is in relation to local vessels. The AFCD, starting from 2004, has stopped issuing import, supply, or sale paints with organotin compounds. And when it comes to international vessels, well, the convention has already been in place. So these international vessels has already covered vessels, and vessels will have to be found to be compliant by classification societies or the local authorities. We've calculated the cost level based on our cost incurred, and we've taken reference from other similar services of certification and examination. Well, for certificate is by certificate, for survey is by the hour. The Marine Department will review its work process, and if there is room for reduction, there will be. And if there is a need to increase the fees because of, say, labor cost, and it will be revised. It says here in March 2001, China became a signatory to the International Convention. So there is already legislation covering it. Mainland fishing vessels or sand barges will not use these the harmful paint. Is that right? Right. Ms. Sit Ho. Well, the garrison law says that garrison is subject to Hong Kong legislation. It's just that we carve them out by exemption with local legislation. It's a very puzzling logic. I know that in Hong Kong a lot of the laws exempt the government. Is it the case that since the government is exempted, you will have to exempt the garrison as well? Yes. The state has entered into the convention, but when it comes to compliance, you see there is a very marked difference. Well, the army stationed in Hong Kong will have to abide by Hong Kong laws. I think Dr. Kenneth Chan's concerns are justified. If the army resident in Hong Kong use other vessels to serve them, and these vessels are not these pilots, say for example, they are not properly registered under the army, but they are used by the army. Say for example, for 80% of the time they operate independently as a private vessel, and 20% of the time they are commissioned by the army. And if these vessels use harmful substance, will they be exempted or not? So how can we ensure that the army stationed in Hong Kong will abide by our laws? I know that this regulation will be endorsed anyway, but do you know if the army stationed in Hong Kong comply with the International Convention by not using harmful substance in that is the anti-fouling system? The only purpose of the regulation is to meet the requirements of the convention. There are 180 states under the IMO, International Marine Organization, and in each country they have their own arrangements. It's not just about the PLA. Maybe the U.S. Army or U.S. Navy will visit Hong Kong. And it's actually for the decision of the IMO, and as to whether the PLA has used the vessels that have this harmful substance, I will try to find the information through the Security Bureau. Vessels in Hong Kong, they are either registered in Hong Kong or in their own authority. So army vessels, they will have to have a place of registration, and they have to comply with the legislation there, and they will in the end comply with this international convention. Well, I don't know if if you have the information about whether the army stationed here comply with legislation. When I know that you have explained that quite some time ago there was already a ban on the sale and import of the harmful paint. And of course, if 80% of the time of the vessels are operating in a private capacity, then they will have to comply with laws. Are there any vessels that are not registered under the army, but they serve the army or the navy 100% of the time? As far as we understand, there is no such vessel.
For vessels operated in Hong Kong, they need to take out a license. I think it all depends on the nature of the business. Foreign navies may come to Hong Kong, they may need service, and then such vessels may be recruited to provide the service. I don't think there will be a vessel that is serving the Navy 100% of the time unless it is a government vessel. So what actually do you mean by the definitions there? Marine Department? We may have vessels owned by the government for the purpose of training, exploration, or rescue, etc. So they will be regarded as a naval auxiliary. In other words, other than warships, all others will be called naval auxiliaries, right? Yes. Are they within the establishment? I think what concerns us most is the establishment, and for anything outside the establishment, it will be regarded as a naval auxiliary providing service on contract. I think that won't be regarded as such. Mr. Obichen, Mr. Chairman, 2 questions only. First of all, the government vessels will be exempted, and the vessels under the Navy will also be exempted. That's the legal position. But what about the administrative arrangements? I want to know whether the Hong Kong government will pledge that all the vessels will be in line with the international requirements. And I want to know how you can make sure that the pledge will be honored. The second question is, I'm not sure about the international arrangements. I know that the warships will be ocean going. They will visit other ports. I understand that there is a confidential nature in relation to the exemption needed for the warships, because even for the U.S. Navy, there will be radar equipments, and sometimes the warships may be driven by nuclear power. For the Chinese government, when it comes to international convention, I want to know whether the Chinese government and other governments, like including the U.S. government, that they will pledge that their own warships will not be using the banned anti-fouling systems. Do you have an answer? We haven't got the information. the Hong Kong government will understand that the government should set an example whenever there are requirements set out in an international convention. I haven't got the information with me. Well, after the meeting, please check. Now, you are giving exemption to the government-owned vessels. Is there any guideline within the government, even though you are not bound by the law? And how do you enforce the administrative guideline? How do you monitor it? So that's the case for the Hong Kong government vessels. And what about warships and warships belonging to the POA as well as other foreign authorities? We don't want to pick on any particular regime or administration. And we can understand that owing to the sensitive information, warships won't be regulated. But still, I'll be interested to know whether there is a pledge and whether we can be confident enough in having trust in the pledge. Is the question clear? Yes, clear, but I have to check whether we can get the information, say, for example, from the consular officers. Maybe we can look up the international convention to see whether there are documents explaining this matter. If not, maybe Hong Kong can work through the Constitutional Mainland Affairs Bureau. And then for foreign navies, I'm not sure about the channels through which we ask the questions, but still we need to get answers from them. So maybe we want to find out from the foreign governments whether they have internal guidelines to say that they will also be having the right kind of anti-fouling systems. Mr. Chairman. It is called Merchant Shipping Control of Harmful Anti-Fouling Systems on Ships Regulation, though the ordinance itself is called Merchant Shipping Prevention and Control Pollution Ordinance. I don't know whether there were previous amendments, but to me, I'm concerned about the air pollution caused by the vessels. For Hong Kong, our air pollution problem originates from pollutants from the mainland. Well, we are soon going to enact a piece of legislation. Once a vessel is moored for an hour, then there will be a particular requirement. In fact, we have a few regulations being lined up. Another one is about littering. Well, in fact, I'm very concerned about the pollutants. I think the pollutants are causing a lot of impacts on new territories west. Yes, this point is clear. Dr. Kenneth Chen, second round. I would like to follow up on the question I asked in the first round. Well, it doesn't matter. How come that I've only uttered 10 words and then my time is up? Now, I'm still interested in the application and the scope of exemption. I'm grateful to the administration for pointing out that Article 3 of the Convention has also got the scope of application. My understanding is that you simply transplant the words from the Convention to your regulation. I couldn't get the Chinese version, but then I got the English version from the UK government's website. Well, in fact, Article 3 of the International Convention does exempt the warships and naval auxiliaries as well as ships owned or operated by a government and used only on government non-commercial service. But in the English version, let me quote from it. Please bear with me.
Parties shall ensure by the adoption of appropriate measures not impairing operations or operational capabilities of such ships owned or operated by it, that such ships act in a manner consistent so far as is reasonable and practicable with this convention. 意思即係話咧係豁免咗嘅，但係公約都有一個。
In other words, there is exemption, but then the convention hopes that even for exempted vessels, efforts will be made, reasonable, practical efforts will be made to align with the convention. So my question is simple. The Article 3.2 of the convention is worded in such a way. Why haven't we borrowed the same wording from the international convention so that it will appear in the local legislation in the exact wording as well?
一個締約國自己係要自我監察。
So every convention party must make sure that this is being done. So it's not a matter of we are monitoring it. Even if we have included this provision, we have to ask through IMO as to whether this particular article has been sort of followed. That is, despite the exemption given to warships and naval auxiliaries, they will still be following the requirements. I think it is relevant. I asked a question concerning the government fleet. Despite being given the exemption, the government fleet will still be compliant. For warship and naval auxiliaries, of course, we can't do anything about foreign navies, but what about our own garrison? I'm grateful to the Bureau for telling me that you have to ask through the Security Bureau. I think it's important for us to note that the International Convention has a very clear expectation, and there is no doubt about it. That is, when it is reasonably practicable. Now, since we are able to get the the AIB, so I don't think we lack the money or technology to be compliant with the convention. I think Dr. Chen's point is valid. We have got something in the original convention. That is, as far as it is reasonably practicable, exempted vessels are expected to live up to the standard. I think you can consider including it in our regulation as well. I see no reason why it can't be done. And in fact, we have been told that since 2004, such paints can no longer be offered for sale. So please tell us why you can't include it as well. When we include a provision in a regulation, we have to enforce it. But then for this particular part in the convention, it is for the IMO rather than a party to the convention, or in the case of Hong Kong, an associate member to enforce the law. Now, it has already been exempted. If we are to include this particular point, then there will be doubt as to whether there is indeed an exemption. Convention countries, convention parties have the duty to make sure that the requirements are followed. Mr. Ho, thank you, Mr. Chairman. We do try to implement the joint declaration as well as the international conventions. There are different styles of drafting. Now we have seen another type that is skipping certain words from the international convention. But in some other cases, you just copy it wholesale, whether it is in line with the actual circumstances in Hong Kong. Say, for example, we have the UN sanctions, and it's a standing subcommittee, and Dr. Chen and myself are on the subcommittee, and you just simply copy word by word. You don't care whether it can be implemented. And then there is this convention on chemical weapons, and then the entire text has been attached to the schedule. Then it will be regarded as part of the legislation. We have asked the government as to why there have been so many different styles of drafting. First of all, let's not talk about which is the best for Hong Kong, but at least you are expected to be consistent. Otherwise, we don't know when you're going to pick a particular model. Now, to us, For such international conventions, maybe not each and every article is in line with the tradition of common law. For us to honor our international obligations, I think the DOJ should try to draft domestic legislation to see that being done. The worst thing is that you have various models. Now, we are not actually saying that we won't agree with you as far as the approach is concerned, because you don't want to give exemption in one provision and try to say that you are also expected to follow the rule. Well, I don't think it is a question to be answered in this subcommittee. I think it's better for it to be addressed by the AJOS. That is, when it comes to implementation of international conventions, should we copy word by word or what? No, I don't think it is something very broad. I think legislative work is our daily life. I think it's best if we can have the same principle being upheld for the sake of consistency. If you have always been copying word by word, I don't see why you can't do so on this occasion, or at least have an approach which is acceptable to both parties. That is, why can't you include the international convention in the schedule to the regulation? Dr. Chen, I think you are quoting from the UK laws, right? That's the English version. The English version of the convention. I'm a scholar, so I have to give the source. Is the English version of the international convention.
I ask the administration to consider it, the reason why it's not put into the legislation. I'll leave it to you, and you tell me the reasons why you have done it this way. May I explain again? Ms. Ho said that there are different styles. It depends on the nature of the international convention. In relation to marine-related ones, yes, we have used the approach of copy and pasting the entire convention in the schedule, but it depends on whether the wordings are suitable. For this one, major provisions, we have transformed them into local legislation. So it depends on the actual situation. Mostly, if it is technical, we'll just copy and paste it. And for things that there is no room for misunderstanding, say for example for the output rate or in relation to machinery, we will just copy and paste. And the reason why we did not include the convention in the schedule, as Mr. Chan said, each party shall ensure. Let me read it out.
By the adoption of appropriate measures not impairing operations or operational capabilities of such ships owned or operated by it, that such ships act in a manner consistent, so far as is reasonable and practicable with this convention.
We're talking about the duty of the individual contracting party. They have been given exemption, but the IMO doesn't want to give them a free rein. That's why they've said that the party shall have the duty to make sure that it complies with the international convention. Any other questions? Well, Chairman, you said the DOJ should answer. Perhaps the DOJ, I ask you to give us an information paper containing what the official has just said, because we need it on record. There are many different styles, and each time we do it, we accumulate experience, and in the end, we will be able to find a system. We don't want an arbitrary approach. It's just a suggestion. I understand that there are many different ways to expression in the international conventions, and as I've said, that there is a clear purpose. You have signified an international convention, no matter what. This convention said that yes, there may be exemption, but you have to be reasonably practicable, comply with the convention. This doesn't have to be there in the first place. So you have to bear in mind that there is this clear expectation in the convention. When you prepare documents for the public or for the LegCo, you will have to bear in mind that this should be reflected. We may have more questions to ask, and if you have missed that, it doesn't matter. You can add it. There will be some time for us to do some research. You've told us verbally that the government fleet is compliant. And for other vessels of other countries, not just China, my understanding that they are compliant. And if you say that, well, there is you don't know, you can't find the information, is state secret, you don't want to be thrown to prison like Gao Yu for 9 years, well, then at least it itself is an answer. Any other questions? If not, we can go to clause by clause. Sorry, speakers not coming through properly. Something wrong with the microphone. We will scrutinize the Chinese version. And the legal advisor will draw attention to areas that needs our attention in the English version. Thank you. Now we go into clause by clause. Well, this is for the Secretary of Transport and Housing to make under Section 3.2 of the Merchant Shipping Prevention and Control of Pollution Ordinance. The effective date will be a date promulgated by way of Gazette. It's not a complicated regulation, just out of curiosity. Why did you not simply put in an effective date? Why do you have to have another subsidiary legislation about the date of operation, and it will be subject to a negative vetting? The international convention applies to Hong Kong. With LegCo's endorsement, we will ask the central authority to inform the IMO before the regulation comes into effect. That's a matter of procedure. 2 is interpretation. It refers, the International Convention refers to the International Convention on the Control of Harmful Anti-Fouling Systems on Ships 2001. Well, where there are amendments, then the convention will prevail. Just out of curiosity. Well, the convention has come into effect. It's just that it's not extended to Hong Kong yet. Well, if there is a chance that the LegCo stops it, then it will not be extended to Hong Kong. But the country has already ratified the convention. Then it will be quite embarrassing. When Hong Kong is a shipping center with so many vessels and ships coming in and out, of course we have to implement the convention. China ratified the convention in 2001. And at that time, the Hong Kong SARG was asked if we were ready. We said that we are awaiting legislation. That's why China told the IMO that it's not extended to Hong Kong yet. But whether that is the case, the central authorities will inform Hong Kong. Yes, that's right. It's just like Taiwan for the service trade agreement, but the public did not agree with it. That's why there was the sunflower movement. In Hong Kong, if it's something simple, technical, then you only have to go through the legislature because the public will not express any concern. But if it's a matter of concern to the public, you should first consult the public before you accept the duty under the convention. This is not a special approach. This is the usual approach. It's not like the colonial days when the public had no idea what has been signed. Next is a convention country, which means a country that is a party to the country, and then there is the flagship, the flag state, and then the commencement date. If we have question, we will ask. Next is anti-fouling system, which is a coating, paste, surface, or device that is used on a ship to control, prevent attachment of unwanted organisms. Length. In relation to a ship means the length as defined in the International Convention on Low Lines 1966 as modified by the Protocol of 1988 relating to it, or any successor convention as amended from time to time and as applicable to Hong Kong. Non-Hong Kong ship means a ship other than a Hong Kong ship. Government surveyor means a person appointed under Section 12 to be a government surveyor. And then it is the International Anti-Fouling System Certificate. There are three parts. They relate to certificates issued by different organizations. A, IAFS certificate, which will be further defined. B, a certificate entitled International Anti-Fouling System Certificate issued by a recognized organization in conformity with Annex 4 to the Convention. Or C, a certificate issued by or under the authority of an administration in conformity with Annex 4 to the Convention. Next is international voyage. Means a voyage between Hong Kong and a port outside the People's Republic of China, or a port in a convention country and a port outside that country, whether in another convention country or not. Next is ship. Means a vessel of any type operating in the marine environment and includes an air cushion vehicle, a hydrofoil boat, a submersible, a floating craft, a fixed or floating platform, a floating storage unit, and a floating production storage and offloading unit. Recognized organizations means an organization recognized by the director under Section 15, and then IAFS certificate means a certificate issued by the director under Section 7. So far, any questions? If not, Section 3 application. This regulation applies to A, a Hong Kong ship wherever it may be, and a non-Hong Kong ship within the waters of Hong Kong. This regulation does not apply to a warship, a naval auxiliary, or any other ship owned or operated by government and used only on government non-commercial service. Sorry, out of curiosity. International voyage. A port in convention country and a port outside that country. What about Hong Kong, between Hong Kong and Kaohsiung? Hong Kong and Kaohsiung is not an international voyage because it's within the same country. Do you think they will agree to that? You don't need their consent. I think this is political. My understanding is one country. Taiwan is a province in China. That is the saying in China and in Taiwan as well. Just out of curiosity. Do we need their consent, or it can be unilateral? Hong Kong laws apply only to Hong Kong ships or ships flying Hong Kong flags. So that applies to Diaoyu Island as well. Well, then the voyage to Diaoyu Island is not an international voyage. Dr. Chan, I don't want to get involved in the relationship between Hong Kong, China, and Taiwan. Well, there is a term that the legal advisor asked questions. It is in relation to the anti-fouling system. There is a term called unwanted organisms. The legal advisor found that in the original convention and in some other instruments, in Chinese, it means 不利生物, unfavorable organisms. However, in this regulation, there are additional words, 航行, which means navigation or voyage. So do we have to add the additional words? If you're only referring to an anti-fouling system, you're only referring to the substance, to the paint, and their use. So do you have to add these superfluous words?
Please switch on the mic. You can speak closer to the mic. If we don't elaborate on it, the reader may not understand what is meant by unwanted organisms in Chinese, 不利生物. Well, the organisms will attach to the hull of the ship, and this will slow down the ship, and so it's better for us to include 不利航行, which means detrimental to the navigation. I think it clarifies. I think you still have to answer this question. Now you're saying that if you say that it will facilitate enforcement, then I won't object to it. Then are you saying that the Chinese version of the international convention is unclear and we are better than them? Of course, I won't pick and quarrel with you on this time. We appreciate your creativity. Now, throughout the world, 不利生物 is the rendition for unwanted organisms. So will Hong Kong be the odd man out, or are we trying to lead the trend, setting the pace? Part 2. Control on anti-fouling systems on ships. This is to implement the control. Subject to subsections 2 and 3, a ship must not on or after the commencement date bear any organotin compounds that act as biocides in the anti-fouling system of the ship. And subsection 2, subject to subsection 3, if the ship bore any organotin compounds that act as biocides in its anti-fouling system before the commencement date, it must, as from that date, bear a coating that forms a barrier to the compounds. Subsection 3. Subsections 1 and 2 do not apply to the following platform or unit that was constructed before 1st of January 2003 and has not been in dry dock on or after that date. A fixed or floating platform. B, a floating storage unit. Or C, a floating production, storage, and offloading unit. Subsection 4. If subsection 1 is contravened or subsection 2 is not complied with, the owner and the master of the ship concerned each commits an offense and is liable to a fine at level 6, that is $100,000. Subsection 5. If an offense under subsection 4 is committed by the owner or master of a ship due to the act or omission of some other person, that other person also commits the offense and may be charged with and convicted of the offense, whether or not proceedings are taken against the owner or the master. Mr. Sin Chung Kai, what is organotin? I know what's biocide. Biocide means something to kill the bioorganisms. What is organotin? In Chinese, it is 有機石. It is organotin compounds, 有機石化合物. There's carbon in the compound. When it is organic, then of course it contains carbon. I studied organic chemistry. It used to be called tributylene compound. It's a chemical term. But what is it? To kill the organisms like the shell life, etc., so as to prevent them from getting attached to the hull of the vessels. The tributylene, we have got the tin, and then say that again. 3C4H9. C4H9. There are 3 of them attached to a tin. It is usually called tributylene compound. This is one of the larger families. Why should this particular one be specified?
It must, from that date, bear a coating that forms a barrier to the compound. 即係咩意思？即係如果佢用呢隻嘢，就要塗一層嘢喺出邊，係，即係防止呢一層嘢唔好接觸呢一個生物。
嗱，呢個防污漆咧，佢係咁。
What does it mean? We ban the use of organotin compounds. This is because there is already scientific literature to confirm that organotin is toxic, so it should be banned. But then the question is, if there is already a coating containing this substance, the solution is to paint a solution so that the organotin compound cannot be released into the water body. Why don't you make it to be scrapped and removed? Well, the International Convention has a phased approach. Since 2003, you are not allowed to have such a coating containing organotin compounds. And after the year 2008, new ships may have organotin compounds. If there is, then you need to apply a barrier so as to prevent the release of the compounds. If you still have it, then you need to have another coating to prevent the release. But there's no requirement to have it removed, no. Is it more dangerous to have it scrapped and removed? After all, it is harmful toxins. And once it has been removed, you need to treat it. Say, for example, in Hong Kong, it has to be sent to the Qingyi Chemical Waste Treatment Center. In the International Convention, there is no requirement to have it removed. Mr. Sin, would you allow me to interrupt? You are the chair. when a ship goes to the dry dock and have the paint being scrapped and removed totally, it is a very expensive process. So when there is a temporary way to reduce the harm done to the marine environment, then it will be acceptable, and then we wait for the next time that is sent to the dry dock, and then the anti-fouling system can be changed into one that doesn't pose any harm. So it is a matter of control of cost. But you only ask for one layer to be applied. So will it be a sloppy job? Well, there is a certain requirement concerning the thickness for ocean-going vessels. So it isn't just a matter of you just apply a thin layer. So are you happy with the answer? All right, let's continue. Part 3. Concerning certification and means of control on anti-fouling systems. And we talk about the application for and issue of the certificates. Section 5, application of Part 3. This part, except Section 11, applies to a ship of 400 gross tonnage or above. Sorry, I'm a bit slow. What is the significance of the 1st of January 2003? I was still on Section 4. When the convention was first drawn up, there was this phased approach. There are two significant dates, 1st of January 2003 and 1st of January 2008. I know, but what is the significance? For the 1st of January 2003, after that date, paints containing organotin compounds can no longer be used. And then since 1st of January 2008, either you don't have the organotin compounds or you have a coating to act as a barrier. Mr. Chairman, I can't quite understand. Now we're presented with this piece of regulation. But what about the convention? When did it come into effect? I'm sorry for being late. I went to the SFC for a meeting. Dating back may, after all, be necessary, but I want to know why it hasn't been presented to us earlier. I had wanted to ask this question. I always want to know why we act so slowly in implementing conventions. Remember that the THB has asked for more resources to increase manpower so as to catch up with the implementation of international conventions. So it is a matter of catching up. Yes, I know you may as well have been seated on that side. Probably everybody in the Liberal Party is more familiar with the nature of the business than the administration. It's better for the answer to come from that side of the conference room. Why so slow? Thank you, Mr. Sin. It was only in 2008 that the convention was extended to the entire world. And a lot of our marine legislation has to implement different conventions. So we've got quite a large volume of legislative work to complete. Yes, we agree that the pace is unsatisfactory, and therefore round about February this year, we approached the Finance Committee to ask for funding so as to create more posts in the Department of Justice, so as to help the THB as well as the Marine Department to expedite the pace of legislative work, in particular amendment of our laws, and one being the regulation before us so as to implement the convention. As to why we still have to put in year 2003, well, we want to implement the convention, and Annex 1 to the convention has set out that we need to give an exemption, and that's being reflected in 4.3. In Section 4.3a, b, and c, anything built before January 1st, 2003, and they have never been sent to the dry dock on or after that date, then they will be exempted. This is to reflect the spirit of the convention. So the convention came into effect in the year 2008. Are we a party to the convention, or we are involved because of PRC? In the year 2001, the Central People's Government ratified the convention. So far, the convention has not been extended to us. When this regulation is enacted, then we will ask the CPG to notify the IMO to extend the convention to Hong Kong. In other words, it has been commenced in 2008, but it was only in 2011 that China ratified it. We need domestic legislation to empower the MD to enforce the law, and then we can allow this international convention to come into effect. In other words, since 2008, organotin compounds have still been allowed to move around freely in Hong Kong administration. For the importation of paint containing organotin compounds, according to the pesticide ordinance, the FCD's approval is required, but the FCD has not given approval for a long time, so we haven't got such paint in Hong Kong. For ocean-going vessels, they need to be in line with the requirements of the International Convention because they need to be inspected and to be issued with a certificate.
Over the past years, the Marine Department has not found any vessels in Hong Kong waters that did not comply with the convention. You did not find any, or you have actually inspected the vessels? Well, if you did not do anything, then you would not find anything. Well, there is a quality control scheme. 5% of the vessels registered in Hong Kong will have to be inspected. So you did not look for it, or you have done so but did not find any. In our routine checks, this is covered. It's covered in your routine inspection. When do you do your routine inspection? It covers what? All vessels. For local vessels, every year they have to go to the dry dock for an inspection. That's for local vessels? Yes. Every year? Yes, most of them. I don't understand. Because they have to be covered by a certificate, which has to be renewed every year. So it's just like a vehicle examination. There are independent examination centers, or it's done by the Marine Department. Some are covered by us, while others are done by recognized or authorized persons. Any other questions? I want to ask about exemptions of government vessels. Can you explain again? That is 3C. This does not apply to warships, naval auxiliary, or government owned or operated ships. Well, for the application, we have adopted one of the articles of the International Convention. Dr. Kenneth Chan said that there is a provision in the convention requiring parties to make sure that their vessels are compliant. But here it says it's any other ship owned or operated by government and used only on government non-commercial service. Why is there an exemption? Why doesn't it cover the Hong Kong government? I understand A and B. C is ship owned and operated by a government. You mean just Hong Kong government or any other government? I also want to talk about a warship because there are a lot of warships visiting Hong Kong, say those from China, from Australia, from the US. They are exempted? Yes. They will be exempted under this regulation. But as we've said that the warship belongs to a state and the state is a contract, is a convention state, we will ask using the IMO network to find out that all these government ships or warships are compliant. Why do we give an exemption to the government? There is a provision in the convention that exempts government non-commercial service. Well, all Hong Kong vessels comply with it. Then why don't you simply delete it? We have to implement the requirements of the convention, so we have to reflect the spirit of the convention. There are overseas vessels coming to Hong Kong. That is, vessels belonging to another government, they should be exempted. So it's a government, not just Hong Kong SARG. Yes. Mr. Sin, we have used more than half an hour on this point. I apologize. Let me continue with Section 6. Ships must have international anti-fouling system certificates. For 2 and 3, it says, 5, 400 gross tonnage. What's the significance? Well, it's stated in the convention. We just mirror it. Why? Why is it included in the convention? There is a definition. It can't possibly covers very small vessels. A line has to be drawn, and it's usually drawn at around 400 or 500 gross tonnage. So, does it mean international voyage vessels? Yes. Please continue. 7. Application for an issue. 6. International Anti-Fouling System Certificate issued by whom? What organization? 6.1 says a ship must have a valid International Anti-Fouling System Certificate. In the definition, you will find 3 types of certificates. Those issued by the Marine Department, those issued by a recognized organization, and those issued by the convention country. You will find the definition under interpretation. There are 3 bodies that are authorized to issue the certificate. Are you clear?
I don't
really understand. B. Recognized organization in conformity with Annex 4. Annex 4 to the Convention is in relation to certificate issuance. Say under what circumstance it will be issued, validity period of the certificate, and what requirements have to be met. You'll find the information in the Convention. For C, authority, referring to what? The local government is explained. Administration, that is the flag state. Please continue. 7. The owner of a Hong Kong ship may apply to the director for an IAFS certificate. The application must be accompanied by the prescribed fee for the issuance. And then 3. Except as provided in subsection 4, the director must not issue an IAFS certificate in respect of a Hong Kong ship unless the director is satisfied that an initial survey of the ship has been carried out by a government surveyor on payment of the fee. On completion of the survey, the anti-fouling system of the ship complies with section 4. I want to ask, when a survey is done by the Marine Department, can you briefly describe to me the process? For the initial issuance, well, anti-fouling paint is put on the hull. We'll look at the package of the anti-fouling paint, the certificate. Certificates issued by you or what? The certificate covering the paint is issued by the manufacturer. And there will be a statement of the manufacturer stating the content of the paint, what's included and what's not, and what is the active ingredients. How many such certificates has the department issued? The regulation has yet to come into effect, so there is none. So how much time do you reckon should be spent on each survey for the issuance of the certificate? Several hours, not too long. You reckon how many certificates will be issued? We have already engaged a recognized organization to do it. Normally, an owner will not ask us to do it. Who are these recognized organizations? 9. We have signed an authorization agreement with 9. 2 have merged, so there are 8. They are internationally recognized organizations. So there is a branch in Hong Kong or something like that? Yes. Something like classification society? They are classification society. What are classification societies? Well, when a vessel operates in different countries, there is an international convention requiring it to be covered by a certificate, and before it is issued, as classification societies are engaged to do a survey and issue the certificate. In other words, these are companies that are responsible for surveys of ships. Yes, they are international certification organizations. Please continue. It says that that is the director may issue an IAFS certificate in respect of a ship if A is a ship that has been transferred to the registry in Hong Kong, B there is a valid IAFS certificate issued by or under the authority of an administration, and C the record of the ship's system in a form specified in Appendix 1 to Annex 4 to the Convention is up to date. Mr. Sin? So under subsection 4, you only need to conduct survey for those registered in Hong Kong, because for vessels of other countries, they are covered by certificates issued by their own authority. Is it the case that all the countries have signed the convention? This regulates Hong Kong vessels operating in other countries. So if it's registered in Hong Kong, it has to be covered. For vessels of other countries, if the country is a convention country, the ships will have to be covered by a certificate, either by their own authority or a recognized organization. Does it apply to fishing vessels in Hong Kong, or it only applies to ships of 400 gross tonnage? It applies to ocean-going vessels. Fishing vessels are not. But it operates in the open sea. According to our definition, it's a vessel that fish, but it doesn't visit other ports. Mr. Sin, ocean voyage refers to voyage between different ports. Vessels will come back to their own port to unload. Well, Hong Kong is part of China. That I agree. Hong Kong vessels are registered in Hong Kong, but there is a possibility that Hong Kong vessels may visit nearby ports. That is, ports that are others. I'm not talking about sensitive places like Kaohsiung. What about Zhangjiang or Xiamen? Then it's not an international voyage. We call this coastal voyage. Since it's not on international voyage, so they don't need to be covered by a certificate, but they are forbidden to use their harmful anti-fouling system. Okay, you can't find the harmful paint here, but the vessel may go to Zhangjiang, Xiamen. China has ratified it in 2011. Still, there are loads of fake stuff on the mainland, and it may be used. So will Hong Kong examine the vessels? Say for Hong Kong registered vessels, if it visits Zhangjiang, every year these vessels will have to be surveyed by the Marine Department, and they have to produce documents. If there's a change of coating, they will have to give us the information when and what. The Marine Department will assess to see if there is a chance that there is incompliance, and if that is the case, the Marine Department can take sample, of course, only on reasonable doubt. So do you regulate fishing vessels or not? Under Section 3, yes. Mr. Sin, let me explain. So a Hong Kong ship, wherever it may be. Mr. Sin, basically this regulation applies to all vessels in Hong Kong waters, plus local vessels, plus Hong Kong registered vessels. They are not allowed to use the harmful paint. It's only a matter of whether it should be covered by a certificate. A certificate should cover vessels that are above 400 gross tons. And it's just that if you are a smaller ship, you can't use the paint, but you don't need the certificate. You will still, during a survey, examine the paint on the hull of fishing vessels to see if it contains organotin subcompounds. Is that right? Yes, it's included in our code of practice. Vessels should not be painted with such a substance.
And then I think you talked about 8 classification societies. So for vessels on international voyages, they go to the classification societies to get certificates. What about Hong Kong vessels, like the pleasure boats? Where do they get the inspection, and who will do it for them so as to get the certificates? Now, ships of 400 gross tonnage or above and engage in international voyages will need a certificate. Otherwise, no need for a certificate, but they cannot apply the harmful paint. Yes, I understand. I know they are not supposed to have the coating again. How can you be sure that they haven't painted such a coating, and who's going to enforce the law? For local vessels, there are two ways to go about it. For the first one, our own inspectors or authorized persons will ensure that by inspecting the records, the paints applied on the local vessels up to the requirements. Well, in fact, the COS has to be issued every year to make sure that the paint on the local vessels is in compliance. You do it, or you ask the authorized persons to do it. For local vessels, there are two types. First of all, we cover some of the vessels. The owner may also choose from our approved ship inspectors. My understanding is that every year they need to get a certificate of survey. Now, you are saying that for the certificate of survey, it's going to cover this element as well. Yes, one of the items will be the paint. For locally registered ships, I just want to find out how you can effectively enforce the law in the future. There is whether the Marine Department has got sufficient manpower to inspect the ships, or you would be focusing on the paperwork, or do you take samples by scrapping? Well, organotin compounds would have been mixed together with the paint. When a ship travels, then the TBT will be released gradually so as to make sure that the mollusk will not be attached to the hull. So the certificate, the IAFS certificate, is lifetime. So when the vessel changes from registration with Panama to Hong Kong, then we'll be interested to inspect the paint certificates as well as certificates from the paint manufacturer, which will act as a declaration of having a compliant paint. And then there's no need for us to inspect the vessel, and we can still issue a certificate. So mainly speaking, it is paperwork. Yes, at this stage it is paperwork based, but then when we are in doubt, we can always get a sample for the purpose of testing, and then the status can be confirmed. When we are unsure, if we think that the certificate may be a forged one or the record is a forged one, I won't say that it is a matter of self-deception. You don't start with a sample testing, so you just have total faith in the paperwork. Well, I think we can read the document. We have got the accreditation bodies, the international organizations. There's no reason for you to doubt. And then if it is a ship that has been transferred to the registry in Hong Kong, if they have a certificate and there has been no major change, then there's no need to redo the work. The Marine Department has explained that every year 5% of the ships for renewal of registration will be subject to random checking. I understand it differently. There are two types of vessels. First of all, we have the vessels on international voyage, and they're assisted by the classification societies. I won't care about that because I want to focus on the local vessels. Local vessels, they do need to take out an IAFS certificate, but of course they need a certificate of surveying, and it won't be prepared or issued by the classification societies. It can be, it may be, or it can be issued by the Marine Department. Who issues the COS? I think you don't need to go out to scrap the sample and have it tested. I think you focus on the paperwork. I think in the case of doubt, you will certainly have to get samples for testing. What is your plan? How many will be sampled for testing? Do you plan to do so? Mr. Sin, what is your question? When you talk about sample testing, does it mean that we need to scrap the materials? First of all, please tell me what's meant by inspection. You just read the documents and that's it? It depends. When it comes to the coating, when you want to paint the hole, you have to go to the dry dock. You will have invoices, you have documents from the manufacturer, and then the Marine Department can refer to such documents. Well, paperwork can be done anytime, and probably that's the basics. But other than the basic work, the paperwork, any other process to be involved for the coating, unless there are doubts arising from the reading of the papers or incorrect records, or there is a complaint. So as we have stated in the law, unless the Marine Department has reasonable ground to suspect, samples won't be obtained, because the vessel has to go to the dry dock, and it all depends on whether there is a real cause for concern. We can only act when there is reasonable ground to suspect. So you talked about 5%, or is it 1% or 0.5%? We can't attach a figure. When there is a doubt, then we can invoke this mechanism to carry out the sampling. Let me supplement. For locally registered locally registered ships, we have the 5% sampling for quality control, not just for the coating, for many other things as well. We'll check the records, the paperwork, to see whether there is reasonable ground of suspicion. Are you happy with that? Well, when would you scrap the sample? It seems that you are just going to get 1 or 2 additional clerks to carry out the work. Say, for example, there is a complaint, or a manufacturer has suspended service, then the Marine Department has ground to suspect, reasonable ground to suspect, and can ask for samples to be scrapped. Acceptable? Not quite. It seems that there's no guarantee. No, not really. Mr. Sin, we have already got another piece of legislation to ban the sale of such paint. Now you are worried that maybe the ship has the coating applied somewhere in mainland. It's in the extreme case. No, it's not an extreme case. What about Hong Kong vessels? I want to know, how often do they apply the coating, and where do they usually get the coating? Well, in the case of a new vessel, before it goes into the water, it has to be applied. It is very expensive. If you want to do it, you have to do it in a dry dock. So if there isn't any particular reason, there won't be the reapplication of the coating. In some cases, during the life cycle of a vessel, maybe some places have been scratched, and then it's a matter of repairing and mending. Again, it is to be done in a dry dock. In Hong Kong, do we still have the dry docks, and how many of the vessels in Hong Kong are built in Hong Kong? My understanding is that we haven't got any dry docks in Hong Kong. We have the floating one. For dry dock, that's what we talked about. But then for the shipyards, they have the slipway. You can have it put up a slipway to do the work. That's for the smaller vessels. For the larger ones, they cannot be done in Hong Kong. So after all, when this is being done in Hong Kong, it is merely a matter of paperwork. The only exception is that when there is repair maintenance, then they have to check the records. I don't know whether it is a matter of misleading. Sorry about that. As a layman, I would have thought that it is a matter of inspection. The surveyor has touched and seen the vessel, but the reality is that he will only read the documents. Why don't you say that there will be initial inspection of the documents? It isn't really a genuine inspection. Well, when it comes to the issuing of certificates, the IMO does have guidelines. And they also use the term inspection or survey. There are also detailed guidelines as to how this is to be carried out. Well, for the guidelines, how does a Hong Kong surveyor carries out the inspection? Well, he will look and he will inspect the paint certificates, like the declarations from the manufacturers, etc. He can just remain in an office. It doesn't have to go out to have a look. He has to, because he has to check that the coating has been applied. He has to be on the site. You can't just look at the read the documents. You have to go out to see that the applicable paint has been applied onto the ship. So all the officers issuing the certificates will do likewise. How many can you cover in a year? Do you have sufficient manpower, or would you be relying on the contractors? I don't think a lot of the survey will be carried out by the government, because we've already entrusted the work with 8 classification societies. Usually the owners will ask the classification societies to carry out the survey and issue a certificate.
Marine Department, would you supply information or document to Mr. Sin about these code of practice? Yes, we can do that. Now, 8. Endorsements of international anti-fouling system. If after an IAFS certificate has been issued and 25% or more of the ship's anti-fouling system has been changed, replaced, or affected by repair, the certificate is no longer valid until the certificate is endorsed under subsection 2, or B, the certificate is endorsed in conformity with Annex 4 to the Convention by the recognized organization who issued the certificate or by an administration. 2. The director may endorse on an IAFS certificate issued in respect of a Hong Kong ship if satisfied that an additional survey of the ship has been carried out by the government surveyor on payment of a fee. On completion of the survey, the ship's anti-fouling system so changed or replaced or affected by the repair complies with Section 4. Ms. Ho, 25%. How did you get that figure? 25% is also under the guideline of the IMO. Yes, I know you have mirrored it, but how can you know that it is 25%? Well, general repair will not be as large as 25%. It's a significant repair and is not a common occurrence. And as to how we arrive at the figure, we rely on professional judgment. Meaning what? What is that professional judgment? Say, it's a service. If it's a small area, then you will know what is 25%. But when it comes to a vessel, because it's curved and it's large, you can only assess by visual inspection. So you will calculate the surface area? Yes. If you use surface area, then it's objective. Say you use the prohibited paint and you put a coating on it, but what if it's eroded? Would you consider the thickness and everything else? Then you can't rely on visual inspection. That's why I asked the question, how do you assess? There may be still a coat, but it's very thin and it's not as thick as required. How do you make a decision? We're talking about surface area, regardless of thickness, right? Because in reply to other questions, you talk about a required thickness of the paint of the coating, but we're talking about surface area here. Here you talk about surface area, but when it comes to the paint of the whole, there is a required thickness. Yes, we can measure it. We can measure the thickness of the deck. These are necessary work in the repair of a vessel, and it can be done. I'll continue with 9. Cancellation of IAFS certificate. The director may by notice in writing to the owner and the master of a Hong Kong ship cancel an IAFS certificate issued in respect of the ship if the director has reasonable grounds to believe that the certificate was issued or endorsed on the basis of false or erroneous information. Director must give reasons for cancelling the certificate in the notice, and on receiving the notice, the government, the owner or the master of the ship concerned must forthwith deliver the certificate to the director. Dr. Chan? The Legal Services Division has followed this up about the mechanism for affected owners or masters. Is there sufficient protection of their rights? It says the director has reasonable grounds to believe that a certificate was issued on the basis of false or erroneous information. And how do you balance the rights of the owners and the duty of the director? If it's found that a certificate is obtained on dubious grounds, are there any penalties? And may I ask the administration to remind us, if the certificate is cancelled, do you have to follow a certain procedure to inform other places or the IMO? Thank you, Dr. Chan, for the question. The cancellation of certificates is made clear in the regulation that the director may only cancel the certificate if it is issued or endorsed on the basis of false or erroneous information that's based on facts. The director, upon investigation, find that there is wrong information about the model or some other information, then it's clear that the certificate is issued based on wrong information. Aggrieved owners can follow administrative procedure to launch or apply for a judicial review. We don't think there is a need to provide for an appeals mechanism as advised by the Legal Services Division. What about penalty? The cancellation of the certificate itself is a heavy penalty because it can no longer sail. Under 14, says that no person should make misrepresentation. So it depends on whether 14 can be used to make a prosecution. Under the International Convention, is there a notification mechanism whereby you have to notify other places about the cancellation? Is there such a requirement? No, there is no notification requirement. They are Hong Kong registered ships. We just cancel the certificate of the Hong Kong vessel. Without the certificate, the vessel cannot sail to other places. What if it's a vessel flying flags of other places? It comes to Hong Kong and you suspect, and in the event found that the information is wrong, do you have the power to cancel the certificate? No. It's a vessel flying the flag of another place. So the cancellation has to be done in accordance with the legislation of the flag state. All you can do is to inform that flag state, yes. The administration said that it's just like talking to a member of the public. If you are unhappy with the decision, then you go to the ombudsman or take out a judicial review. So we have to ask, when the department exercises its power under Section 9, should there be administrative measures to remind the owners or master of the ship that they can follow a certain procedure to lodge their grievance? It says in the regulation, if the certificate is cancelled, reasons will have to be given in writing. If the affected party is aggrieved, of course, an appeal can be lodged under administrative measures. We do not easily cancel a certificate because it causes a huge impact on the operation of the vessel. So it will only be done when supported by strong grounds. When it comes to procedural fairness, do we need an appeal mechanism in the cancellation of the IAFS certificate? Or you all think that it doesn't matter if you're aggrieved, then you use other means to lodge a complaint? I would like to hear from the administration. I myself think that when local vessels would not want to take the risk and there is no non-compliant paint available in the market. And as the Marine Department said that if the certificate is cancelled, then it can't operate. And of course that the aggrieved party will use different ways to appeal. Well, if you're not happy with the decision, then you can appeal. But if the decision is based on a fact that you've done something wrong, what is the matter under appeal? Do you really need to have the matter looked at by a third party? This is a matter of fact. So it's very simple. If the owner can produce proof that the understanding of the Marine Department is wrong, then the department is willing to look at the evidence. And of course, we will take legal advice to see if the director has indeed got reasonable grounds to cancel the IAFS certificate. The threshold itself is very high. We have to have reasonable grounds to believe that it is false. So there is no need to put in place, in particular, an appeal system. I don't think there will be any difficulties. Well, if the owner is not happy with the decision of the Marine Department, just take some sample of the paint and have it examined. So I'm not very concerned about this. No, it's not a matter of whether you're concerned or not. We can't give an exhaustive list of the different scenarios. And I don't mean to doubt the approach adopted by the government. It's just that when the director has reasonable grounds to believe that the certificate was issued on the basis of false information, that the certificate will be cancelled. But from the answer I get from the government, it seems that there is room for dialogue. That you will say to the owner that we have the information and we are going to cancel your certificate, and this a chance for you to rebut me. But because from the verbal answer there is a dialogue, but from the regulation provisions there is none. Well, I hope that we can complete this, but I'm not sure. Do you object to the extension of the meeting by 15 minutes? Will the officials be able to stay? Please continue. We will conduct investigation. It's only when there is sufficient evidence that we cancel the certificate. We believe that during the investigation, and if there are suspicions, the Marine Department will ask questions. So after completing the investigation, questions asked, and there is still reasonable grounds to believe. So there is a dialogue, as you call it. And if it's only after that it's found that there is false information, that the certificate will be cancelled. If the government is sued, we will have to pay compensation and damages to the loss, and so it won't be a rash decision. Perhaps we get information about the mechanism to ensure that both sides are given the opportunity to state their grounds. 10. The owner and the master of the ship must ensure that the certificate issued and it's for the time being in force, kept on board of the ship and made available for inspection. There is penalty, is a level 6 fine, and if the owner or master, due to fact of omission of some other person, commits an offense. 11. Declaration of anti-fouling system. It applies to ship of 24 meters or more in length, less than 400 gross tonnage, engaged in an international voyage, and it excludes a fixed or floating platform, floating storage units, and floating production storage and offloading units. This declaration will have to be kept on board and made available for inspection at all reasonable times. The declaration must be in the form specified in Appendix 2 to Annex 4 to the Convention, signed by the owner of the ship and an agent authorized by the owner, and accompanied by appropriate documentation showing that the anti-fouling system complies with Section 4.
Subsection 4 sets out the penalty. The owner and the master of a ship who contravene Subsection 2 each commits an offense and is liable to a fine at level 6. No questions? All right. Please carry on. Part 4. Powers of Director and Government Surveyors. Section 12. The Director may appoint a person to be a government surveyor for the purposes of this regulation. Section 13. Power of government surveyors to inspect, examine, etc. ships. any of the persons conferred by this section may be exercised for the purpose of ascertaining whether this regulation has been or is being complied with. Subsection 2. A government surveyor may at any reasonable time A. board a ship that is within the waters of Hong Kong, and B. take with the surveyor any other person and any equipment or materials required to assist the surveyor. Subsection 3. After boarding the ship, the government surveyor may do certain things set out in subsections A to K. Inspect the ship, make any examination or investigation as the surveyor considers necessary. Subsection C. 13.3 from A to K. I want to know whether they are already in existence in the laws of Hong Kong in relation to the Marine Department's powers and procedures. If they are, I don't find any problem, with the exception of H, which says require that the ship or any part of it or anything on the ship is to be left undisturbed for so long as is necessary. Will it take a long time? Or after you have taken a photograph, would you say that everything has to be left intact, undisturbed? You can't touch it, you can't remove it. I think we need to strike a balance. On the one hand, we don't want the evidence to be destroyed. We don't want them to disturb what you have already examined. At the same time, we don't want the powers to be excessive. If the procedure takes a long time, it means that the owner will be prevented from operating the vessel. So what is meant by for so long as is necessary for the inspection, etc.? Well, first of all, I have to say that as far as the maritime laws in Hong Kong are concerned, we have got something similar under Cap 369. Your second question is about subsection 13H. Well, the convention has a particular article to say that we should try our best not to affect the operation of the ship, and you should not be delayed. So we'll be following the same principle here. Mr. Chairman, can the official be clearer? Of course, none of us would like to have a second meeting, both myself and members present, but still we hope the answers can be clearer. Chairman, I don't mind if we say that we have an extension of another 15 minutes. Why don't we finish everything before we call it a day? All right. Generally speaking, once on board, if there is doubt, then a sample has to be taken and the procedures have to be followed. We don't want to affect the operation of the ship. Well, Chair, I think for technical officers, they are very straightforward. But then they do not come to meetings with us too often, and so they may not be used to the way that we discuss the matters. I don't think they need to be so worried. As Emily has said, we are not man-eating monsters. So just now, the Marine Department colleagues have said that the samples will be taken and then the operation can carry on. But then we're talking about the coating in the hull. Does it mean that after the samples have been taken, the ship will be released and can carry on with the navigation? On this occasion, the sample will be taken from the bottom. No, on the side. Just a little bit above the water mark. There are many different ways to do it. They can have a smaller vessel moored next to it, and then some paint can be scratched and scrapped. As to how the sample is to be taken, again, it will be governed by detailed guidelines. If the sample is to be taken from the side of the body, then the operation will not be affected at all. It will only take a few hours, depending on the experience, who is getting it, and whether the sea is calm or not. It's easier when the sea is calm. It will only be taken from the side of the body, so the operation won't be affected. See if I understand it correctly. The ship has to be stopped for the sample to be taken. You will take the sample to the laboratory. While you are awaiting the outcome, the vessel can just operate as usual. So when you talk about for so long as is necessary for the inspection, will that cover the waiting period? After the sample has been taken, the sample will be sent to the laboratory. The vessel can carry on with its activities like getting loaded or leaving Hong Kong. Say, for example, it is in the process of midstream operation and it is a Hong Kong ship. So they can carry on with the activities. All you will be doing is to scrap some materials for the purpose of sampling. So that's what is being meant by 13.3H. Mr. Chairman. There isn't a power to detain the ship, but we usually find such a power when it comes to the regulation of ships and aircraft. What about there is a breach of the law? Are you empowered to detain the ship? Well, under this piece of legislation, since testing is involved and it takes time, so I don't think we need to detain the ship just for this purpose. How quick can it be done? If the test shows that the paint is problematic, it is more than likely that the ship would have already left Hong Kong. How long will it take to test the sample? We need to give the sample to the government laboratory. As to how much time it will take, I don't think I have the information with me. Say if it is found that there is a case of breaching the law, what will happen? We'll go after the company. Sorry, speaker is off mic. Sorry, the speaker is off mic. Will you deny entry the next time it comes to Hong Kong? We'll make a record. If the ship is to come to Hong Kong again, we will, first of all, deal with this issue. There is a mechanism, there is a database to record the problematic ships will be put on the alert. Yes, if the test shows that there is a breach and if the ship is allowed into the port of Hong Kong again, it is a waste of time. Well, you need to allow the ship to come in before you can enforce the law. Well, you have already got evidence to say that the paint is non-compliant. Then you ask the ship to stay and then the certificate will be cancelled. So they have to deal with the problem immediately. Otherwise, the ship will be prevented from departure. Well, the test shows that it is a case of non-compliance. If the flag state doesn't deal with it, and if the ship comes to Hong Kong again, then we can exercise the power to detain the ship, because it is very clear that it is not following the international convention and local legislation. Sorry, I'm talking about Hong Kong vessels, the vessels with Hong Kong flags. Say a Hong Kong ship has the sample taken and the ship has left Hong Kong to do other things, and then the test shows that it is a breach, and then you must allow the Hong Kong ship to come back to Hong Kong for you to enforce the law. Once having entered, you will cancel the IAFS certificate, there will be penalties and they must carry out remedial action, right? Mr. Chairman, it only gives the penalty, like the size of the fine, but we are not told about the administrative procedures. Yes, we hope to finish the work within one meeting, but still the government should give us information after the meeting to tell us what will happen afterwards. Say there is a sample, a breach has been established, what will happen to the ship, both in the case of a Hong Kong ship and in the case of a non-Hong Kong ship, and that will complete the picture. Yes, I agree with you. Can this be done? Yes. So for 13A to K, basically they are similar to the requirements involved in ship inspection. Can we skip that? All right, we can continue with Section 14, obstruction and non-compliance with requirements. No one can willfully obstruct a government surveyor in the exercise of any power conferred by Section 13, or make a statement or sign a declaration that the person knows is false, or recklessly make a statement or sign a declaration that is false in purported compliance with a requirement in Section 13(3)(1). For 14(2)(4), a person must comply with a requirement imposed on a person. 3 and 4 about the penalties. Section 15, I've mentioned this. The director may recognize organizations to survey ships and issue certificates. The director may recognize an organization for carrying out surveys of anti-fouling systems of Hong Kong ships of 400 gross tonnage or above and engaged in international voyages in conformity with Annex 4 to the Convention, issuing international anti-fouling system certificates in respect of those ships in conformity with Annex 4 and make endorsements in conformity with Annex 4, alter any particulars and issue certified true copies of the certificates. Section 16. Director may issue IAFS certificates, etc. at request of Convention countries. That's about non-Hong Kong ship within Hong Kong waters. Just now, we've already visited Section 7 and Section 8 in relation to the survey. So the director may issue an IAFS certificate and give endorsements. Does it mean that at the request of other countries, other Convention countries, the Director of Marine Department in Hong Kong may survey a ship, give approval, or cancel the certificate? Say, for example, in the case of false information, that's about non-Hong Kong ships. For non-Hong Kong ships, it isn't a matter of cancellation. We haven't got the power, but we will carry out a survey, we can issue a certificate, and we can endorse on a certificate at the request of a particular Convention country.
We have no problem. Do you have to extend further? I thought it's implied. You will have to say it. So, with members' agreement, let's have the meeting until we've finished all the matters. Thank you. 17. The director may request Convention countries to survey Hong Kong ships. Convention country may, upon the request of a director, carry out inspection of Hong Kong ship of 400 gross tons and above in an international voyage and issue an IAFS certificate. 18. Alteration of IAFS certificates. The owner of a Hong Kong ship may apply to the director for altering any particulars contained in the certificate. The director may, on payment of a fee, alter the particulars contained in the IAFS certificate if the director considers that the alteration is not a material one. 19. Certificate true copies of IAFS certificates. The owner of Hong Kong ship may apply to the director for the issue of a certified true copy of an IAFS certificate issued by the director. The The application must be accompanied by the fees for the issue of the copy. Do you have to go through the explanatory note? No? No. Then we can continue. The next one is a very simple one. Merchant Shipping Prevention and Control of Pollution Fees Amendment Regulation 2015. Thank you. This is to enable the Marine Department to charge fees for the survey of ships and the issuance of certificates. The regulation comes into operation on a date to be appointed by the Secretary for Transport and Housing by notice published in the Gazette. The first one with change is Section 2 to repeal or and add or after the semicolon and after paragraph B add to be a government surveyor under the Merchant Shipping Control of Harmful Anti-Fouling Systems on Ships Regulation. And then in Schedule 1 is in relation to specified services. After paragraph 2, add 3, an initial survey or additional survey within the meaning of the Merchant Shipping Control of Harmful Anti-Fouling Systems on Ships Regulation. This enables surveyor to charge a fee. Next is amendment to Schedule 2 to add after paragraph 2 an IAFS certificate within the meaning of the Control of Harmful Anti-Fouling System of Ships Regulation. This is to enable a charge of fees for the certificate. Okay. I asked members to note that on the 14th of April, the Chairman of the HCN Drew Leung has extended the scrutiny period of the subleg to 13th of May 2015. And I'd like to ask members if they think there is a need to have a public hearing. Well, the trade has no comments because it's already been practiced for quite some time. Okay, I asked the administration to, as soon as possible, give us a written response, and if necessary, the subcommittee will convene another meeting. Just give us the supplementary information ASAP. That is, well, if there is an irregularity spotted, what happens afterwards? I think it can be included in the subcommittee's report, because if someone wants to find out what is going on, you will be able to see the whole picture in the subcommittee's report. And I'd like to ask members to note that on the 24th of April this year, Friday, I will make a report to the House Committee. Any other matters? If not, thank you.